there are major corporations, mega corporations in the United States who are currently trying to block the efforts of their American employees, of whom they have too few, I might add, from engaging in collective bargaining. And there's no worse example of this than Amazon. Let me show you a picture here. These are Amazon workers on Staten Island who were voting to unionize back in 2022. This was a huge landmark win for labor and for the employees. It took them years to get to this vote. Amazon, of course, fiercely resisted it, did everything they could to try and stop it, pulled out all of the stops, and yet the employees, as is their right, of course, under the law, voted to unionize. Now, after they did so, Amazon proceeded to engage in a delay of 4 years before they entered into negotiations for a first contract with management. 4 years. Now, as you know, federal law requires bargaining, good faith bargaining, to get to that first contract, but Amazon delayed and delayed and delayed. Then a few months ago, the Teamsters president, Sean O'Brien, sat right where you two are sitting and explained that this is common practice across the industry in these multinational mega corporations, Amazon being one of the worst offenders. They deliberately delay and hold up the process of getting to a first contract. I was stunned to learn that the average time to a first contract is 465 days. Now, I emphasize this is after the employees have exercised their federal right to collectively bargain. 465 days. In half of cases, just about, it is over 2 years before there is any kind of an agreement at all. So let me just ask you, first of all, are you familiar with this issue? Are you concerned about it? Mr. Prouty, go ahead.
Thank you for the question, Senator. Yes, I'm obviously aware of it, and I'm concerned about it. As I've said publicly, the remedies available under the Act are somewhat limited. I'd invite the Congress to strengthen the Act, but we process cases as expeditiously as we can. We have a huge backlog, as you know.
Absolutely. Mr. Macy, I want to come back to your point about what Congress should do, but Mr. Macy, go ahead. Are you familiar with this problem? Are you concerned about it?
I am aware of it, and I am concerned about it.
Good, good. I'm glad to hear that. Well, I agree with you, Mr. Prouty, that there's steps for Congress to take here, which is why I'm pleased that yesterday the House of Representatives passed legislation that I wrote and introduced on this side of the Capitol, along with my friend Senator Booker. Senator Marshall is a co-sponsor, a number of other my colleagues on the other side of the dais. I called the Faster Labor Contracts Act, and it just tries to actualize the requirements that are already in federal law, namely that employers, once their employees have voted, as is their right, to unionize and collectively bargain, we put a shot clock on that bargaining process so we can get to a first contract. As I said, that legislation passed the House. It would be enforced if it were to pass the Senate, be signed by the President, enforced by the NLRB. Do you think that providing more of a framework, creating a framework for a first contract, putting a timeline, putting a shot clock on those negotiations. This bill also provides for arbitration, that parties can choose their arbiters and so forth, but if they can't reach a contract within a certain amount of time, then we get arbitrators to help them. Does that sound like the kind of thing that would help, again, give voice, make actual and real this right that employees already have under federal law? Go ahead, Mr. Prouty.
Senator, I've got to put on my hat of board member. It's not really appropriate for me to comment on legislation either way on what would improve the act. My job is to enforce the act as it stands.
But you would enforce it if it were passed?
I would.
Good. Mr. Macy?
Thank you, Senator. The same, I'm in a position that it would not be appropriate for me to comment on pending legislation, but to answer the next question, I anticipate is if it were passed, we would abide by the law.
Good, good. Well, I hope that you'll soon have the opportunity to enforce it. I'll do my best on my side of things here, but I think it's vitally important that we make real the guarantees that are already in federal law. Let me just ask you one other question here in my time remaining that's also related to Amazon. Let me show you another Amazon-related picture. This, I think, will be familiar to everybody in the room. We've got an Amazon truck. We've got an employee here who is wearing an Amazon-branded T-shirt and other logos, hat, carrying an Amazon package. Now, you might think that this person wearing all this Amazon gear, carrying the Amazon package, is an Amazon employee, but oh, lo and behold, she's not, according to the company. The company runs a third-party organization, a delivery service provider that they also control and subcontract with for the purpose of avoiding having to pay this good person full wages, healthcare benefits, giving her the benefits of other rights that have been won in collective bargaining. My question to you is, I'll let you take a first stab at it, and I'll follow up with some questions for the record. Don't you think it's time that we put an end to this kind of blatant attempt to avoid federal labor law? Amazon has for years operated this program with the sole intent of avoiding having to pay these people, who they say are not really their employees, though they micromanage their schedule to the second every day. Don't you think it's time that we put a stop to their attempts, Amazon's and others, to evade federal law and the requirements of collective bargaining by treating these people as if they're not really their own employees? Mr. Prouty.
Senator, as you may know, that very issue is on my desk right now, and so I can't really comment on it.
And just tell us why it's on your desk, because the NLRB has taken action on this.
There is a proposed settlement of an outstanding case, which is before us for review.
Well, Mr. Chairman, I know my time's expired, so we'll leave it at that. I'll have some follow-up questions for you. Can I just finish by saying I think that this is outrageous, what is over my shoulder here. The idea that this employee, who is every moment of her life practically is directed by Amazon, yet they don't have to pay her, they don't have to honor the commitments under collective bargaining that might apply to her, I think is ridiculous. And if the NLRB doesn't have the authority to do something about it now, we should give you that authority. Thank you, Mr. Chairman.
A fiery exchange unfolded on Capitol Hill during a recent Senate committee hearing, casting a harsh spotlight on the aggressive anti-union strategies deployed by multinational megacorporations. A fiery exchange unfolded on Capitol Hill during a recent Senate committee hearing, casting a harsh spotlight on the aggressive anti-union strategies deployed by multinational megacorporations. The focus of the hearing quickly shifted to a blistering critique of Amazon, with lawmakers demanding answers from federal labor nominees regarding corporate evasion of American labor laws. The discussion opened with a stark reality check regarding the hurdles American workers face after successfully voting to unionize. Presenting a photo of Amazon workers on Staten Island celebrating their landmark 2022 unionization victory, the presenter underscored a frustrating truth: winning the vote is only the first battle. Following that historic win, Amazon reportedly engaged in a staggering 4-year delay before even entering into negotiations for a first contract with management. This is a blatant, calculated strategy designed to break the spirit of unionized workers. Federal law mandates good faith bargaining, yet megacorporations regularly treat these mandates as optional. It is absolutely stunning and completely unacceptable that the average time to secure a first contract in this country is 465 days. In nearly half of these cases, workers are left waiting for over 2 years. This isn't an administrative backlog. It's deliberate corporate foot-dragging meant to stall progress until the union momentum fizzles out. When pressed on this issue, National Labor Relations Board nominees Mr. Proud and Mr. Macy both acknowledged the problem and expressed concern. However, they pointed out that the current remedies available under the National Labor Relations Act are frustratingly limited, effectively inviting Congress to step in and strengthen the law. In response to these systemic delays, the presenter highlighted the Faster Labor Contracts Act, a bipartisan piece of legislation co-sponsored with Senators Booker and Marshall. The bill, which recently passed the House of Representatives, seeks to put teeth into existing federal law by establishing a strict timeline, a corporate shot clock, for first contract negotiations. If the parties fail to reach an agreement within the window, the bill implements a framework for choosing arbitrators to step in and finalize the contract. While both nominees declined to comment directly on the pending legislation due to their strict roles as impartial board members, both explicitly confirmed that they would fully enforce the framework if it passes the Senate and is signed into law. The scrutiny intensified when the presenter introduced a second photograph displaying an Amazon delivery driver. The driver was fully outfitted in Amazon-branded gear, wearing an Amazon t-shirt and hat, driving an Amazon-branded truck, and carrying an Amazon package. Yet, under corporate guidelines, Amazon claims this individual is not an employee. Instead, the tech giant utilizes a massive network of third-party delivery service providers to subcontract the work. The presenter's perspective, this setup is an absolute farce and a blatant dodge of federal labor law. Amazon micromanages these drivers' schedules down to the very second every single day, dictating every aspect of their regular routine. Yet, by hiding behind the legal fiction of third-party delivery service providers, they duck out of paying full wages, providing healthcare benefits, or honoring hard-won collective bargaining rights. It is ridiculous, It is outrageous, and it represents a cynical exploitation of the American workforce. When asked if it was time to end this widespread evasion, Mr. Proud revealed that this exact issue is currently sitting on his desk at the NLRB in the form of a proposed settlement of an outstanding case, preventing him from commenting further. This hearing laid bare the deep systemic flaws in how federal labor laws are enforced against corporate giants. When companies can delay contracts for years without consequence, or use subcontracting loops to pretend their core workforce doesn't belong to them, the legal right to collectively bargain becomes a hollow promise. If the NLRB currently lacks the teeth to penalize these flagrant attempts to bypass the law,